Hi drivers, Paul Taylor from Truckers Justice Center here. We are a law firm representing drivers, commercial vehicle operators generally in disputes with their employers or former employers or carriers who they are leased to. So I want to talk about a misconception that people make frequently, and that is the misconception of what a right to work state is. So I get probably 6 to 8 contacts a day from truck drivers, either online, Facebook Messenger. Please don't do that because it's not privileged attorney-client privileged communications, but online inquiry forms, email, phone calls to our office, phone calls to my cell phone. And they usually have been fired or about to be fired, at least in a lot of these drivers who contact us. And I say, well, why do you think they fired you? Well, they didn't like me. Well, then people are entitled to fire people they don't like. So I probe further and say, well, what do you think is what is the reason they gave? And they'll say, well, I failed a controlled substance test, but I've never used marijuana, Mr. Taylor. I just used some CBD oil. And I said, well, okay, that's the reason they gave. What do you think is the real reason? Well, that's it. Well, under the doctrine of at-will employment, you may be fired for a good reason, a bad reason, an unfair reason, no reason at all. You just cannot be fired for an unlawful reason, which means there's a law that Congress has passed and it's been signed by a president or overridden by a presidential veto. Some president somewhere, like the Americans with Disabilities Act or the Family Medical Leave Act, there's a law that can modify at-will employment. So either a president has signed a law passed by Congress that prohibits employment discrimination or discharge on the basis of certain reasons, or a state legislature. In the case of Minnesota, where I live, you cannot fire somebody based on sexual orientation in employment. That's a Minnesota Human Rights Act. It is not in Title VII of the Civil Rights Act of 1964, which covers race, religion, national origin discrimination of that era. So there needs an employer in the free enterprise capitalist system is free basically to fire employees for whatever reason they want, so long as it doesn't break a law. There's no general lawsuit claim for wrongful termination. You know, people will call us and say, I want to bring a wrongful termination suit. Well, again, why'd they fire me? Well, they didn't like me and I'd been there 20 years. You know, well, that needs to be probed further. There's not a general, this is wrongful, okay? For example, the person behind the camera here is Cassidy, who's worked for this law firm for about 14 years. Very competent and loyal. And I could fire Cassidy in order to make room for a pot-smoking, drunk, schizophrenic, or mentally ill buddy. Would that be wrongful? Sure, in the moral sense. But it's not illegal. We have private property rights in this country, and employers, through their shareholders, have those property rights. They can be modified to a certain extent where there's been a law prohibiting a particular type of firing. So think of the common ones: age, race, religion, a qualified disability, use of Family Medical Leave Act leave, national origin, and some states sexual orientation. Most of what we do, our cases under a law called the STAA that prohibits retaliation or discrimination or discharge because a driver has either made a complaint about a violation of commercial vehicle safety regulations to the employer or the government, or has refused to violate a commercial vehicle safety regulation. So those are some reasons that are legitimate to fire people. Now, talk about right to work. Drivers say, I said, well, they can fire because they don't like you. Yeah, I'm in a right to work state, and I'll say a little bit in a smart alecky way, oh, what union did they want you to join? Right to work is often confused with at-will employment. Right to work means you cannot be compelled to join a union in a, if you work for an employer who is union organized, and that only applies in states where there are right to work laws. So typically a union, if they've organized a shop like YRC, UPS, they have signed exclusive agreements to bargain with the Teamsters. Or, it could be sheriffs too. It doesn't have to be, or county attorneys are actually Teamsters in the county where my office is located. But in a right to work state, even where the employer has signed a bargaining agreement with a union or with a union or its local agent of the union, and you're in a right to work state, you cannot be compelled to join that union. You cannot be compelled to pay union dues. And get a load of this, you get to be a complete freeloader, because the union has a duty to represent individuals who are non-union but are, where they have a union agreement. So if you're a driver in Alabama where there's a right to work law and you're working for UPS and you don't want to join the union, you don't have to. And you don't have to pay union dues, but if you're fired, the company still has to have just cause under the contract to fire you, or they have to have a reason for, say you showed up for a drug test that you failed, or you had a serious crash. The union still has to represent you in a right to work state where they have had a contract to be this exclusive bargaining agent of the employees. You don't have to pay dues, and you get to freeload on the hard work of the union representatives who represent you. So there is a big difference between at-will employment and a right to work law. Big mistakes people make is misconstruing the two. They are entirely different concepts. And for your information, there is only one state in the country, in the United States, that is not an at-will employment state, and that is the state of Montana. In that case, except in a certain period of time, initial employment, you're at will, but at a certain point, they have to have cause to fire you. The exceptions to at-will employment are, in summary, one, they're firing you for a reason that is prohibited by law, or two, you're working for a unionized employer and they have violated the collective bargaining agreement. Three is if you have an employment contract, which could technically include owner-operators in some cases, but remember, most owner-operator agreements said they can cancel your contract at any time. Thanks for watching.